All right, we'll go ahead and get started. Welcome to CIT Echo, everyone. It's good to see you. As always, we'll get started with introductions of those connected. First person I see is Kimberly McManus.
Hi, everybody. I'm Kim McManus. I am the CIT Echo Project Coordinator.
I see Dr. Nancy Martin.
Hi, everybody. Nancy Martin, Presbyterian Psychiatry.
I see Officer Adan Corral from APD. Not sure if you have a mic, sir.
I do. Good morning, everyone, or good afternoon.
I see Detective Albert Romero.
Hello, Detective Albert Romero, APD-CIU.
I see Lieutenant Amy Sedler from APD. I believe she said she did not have a mic. I see Brienne Bellio, who also said that she did not have a mic, although I have the agency from Arvada Police Department in Colorado. Welcome. We can have a discussion later about whose green chili is better, ours or Colorado's. I see Sergeant Charles Crook. Maybe Sarge doesn't have his mic up and running yet. Let's see. I see David Olarhars. Not sure if I'm saying your name correctly.
Good morning, everyone. David Olajars from Addison, Illinois Police Department.
Welcome, sir. I see Dr. Elizabeth Ferre.
Hi, I'm Elizabeth Ferre from UNM.
I see Jim McGregor.
Jim McGregor from the Tarrant County College Law Enforcement Academy in Fort Worth, Texas.
Welcome. I see Detective Mark LeClaire.
Hey, Detective Mark LeClaire, APD's Crisis Intervention Unit.
I see Michael Lucero.
I'm Michael Lucero, clinician with APD-CIU.
I see Dr. Niels Rosenbaum.
Hi, Niels Rosenbaum, psychiatrist with APD.
I see Major Sanchez.
Randy Sanchez from River County Sheriff's Office. How's everybody doing?
Good, sir. How are you?
Yeah, good. Thanks.
Great, thanks.
I see Sergio Hermosillo, I believe from the United States Marshal Service. Is that correct?
Yes, sir.
Welcome.
Thank you.
Let's see. I see Stefan Bij, I believe from agency in Illinois, if I'm not mistaken.
Yeah, Stefan Bies. I'm with the Addison Police Department in Illinois. I'm a western suburb of Chicago.
Welcome.
He's my boss.
Oh, I see. Gotcha. I see Tasia Sullivan from APD/FBI. Not sure if Tasia
Hey, everyone.
has...
Sorry.
Oh,
I'm here. Hi, everybody.
I see Michael Martinez from the Bernalillo Police Department.
Good afternoon, everybody.
I see Sergeant Tony Lockhart from King County. Welcome, Sarge.
Hey, Ben. Good afternoon, everybody. We're hiring.
I see Chief Mengiacapa from Corrales PD here in Albuquerque.
Hi, Vic Mengiacapa, Chief of Corrales PD, and thanks for having us, Ben. Good to see everyone.
Good to see you, Chief. I think that's everybody, although I did see somebody type that they were just a lowly patrol officer. Oh, I see. I wanted to say, David, that I relate to that. I'm also a peon at the department I work for, so good to see somebody else sharing that position. All right, so as always, we'll get started with our case. Our case is a very interesting one and directly ties into our didactic. Our case today is being presented by Detective Mark LeClaire, so I'll let him make that presentation.
All right. Hey, everybody. So yes, today is the red flag law, also known as IRFPO. emergence. I don't remember what the acronym's for, but yeah, it's the red flag. So I got this case because I was the newbie, and nobody in my unit had done anything like this before. So I was kind of the guinea pig for this case, in one of the very first red flag law cases to be completed, I guess, was my understanding. So a woman had contacted the department requesting the red flag. She got the for her father. She filled out the proper documentation and sent it to me. So after I got what she wrote, I did my own background to look into his history and his background. She had only listed like 2 incidents, maybe from last year, where he was in an argument and one where he was suicidal. He is a veteran. I'm trying to remember what branch, but so he is a veteran. The one time he was suicidal last year, he went willingly with officers to the VA. And the other argument that she listed with his wife, there were no threats of violence or any violence that occurred during that incident. So I went further in the background. He didn't really have any other reports in our system to indicate any type of violence or anything like that. So what I did after that was I contacted the VA's Beacon Clinic to get their perspective on how they felt this individual was mentally, and if they felt there was any reason for his firearms to be removed from him for the year. I believe that it has to be renewed every year for them to continue keeping the firearms from him. So when I talked to a doctor at the VA, he said that Ruben, as far as they know, did not have a history of violence. His last suicide attempt was in the year 2000, and that Ruben was the individual was diagnosed with major depression and PTSD. They said he was medication compliant, and they did not see a reason for his firearms to be taken away, or even enough for them to write a certificate of evaluation for him to be brought in against his will. One of the other incidents that the female listed that was a concern for her was when she was in like elementary school. Her father had mentioned something about shooting up the school, but this woman is now in like her 40s. So there was no immediacy there to really cause concern that it happened decades ago. I also staffed this with our APD psychiatrist, Dr. Rosenbaum, who's here today. And we all kind of came to the conclusion that based on the information from the Beacon Clinic with the VA, the information provided by the daughter, and consulting with him, that there was not enough findings to move forward with this red flag case. I also reached out to the district attorney's office, who said that even though it's listed in the special order, or whatever you want to call it, the things to do for a extreme risk firearm protection order, is to contact them. They said they do not consult with us on these cases. So that was super helpful, especially since I had never done one of these before and really had no guidance other than here's what the policy says to do. So basically, I collected all that information from his background, from the VA, consulted with our psychiatrist here on staff, tried to consult with the DA's office. And based on my findings, I did not find that he met the fairly extensive criteria to move forward with the red flag. Because, and I guess it also comes down to kind of the detective who's doing the case to determine if they find enough and believe that it's necessary for this to get filed and go to court. So based on my background, I determined that there was not enough, and I was not willing to put my name saying, yes, this male's guns need to be taken away from him. So I ended up completing a report stating that and filed it with the Bernalillo County Sheriff's Office. I guess my question would be, based on what I did, can anybody think of maybe anything else I could have done to look more into his background? What the daughter gave me, I kind of had to go off of her affidavit of saying, this is why I think his gun should be taken away. But any other suggestions that maybe I should have checked somewhere else?
Excellent. Thank you, Detective LeClaire. Very interesting case, and more interesting because it was sort of the first delve from the Albuquerque Police Department into this sort of new law. Dr. Frey, a quick recap.
Sure. So this is a male individual history of MDD and PTSD, whose daughter contacted law enforcement asking to take advantage of the red flag law. She reported 2 instances in which father, who's a veteran, had been suicidal in the past or violent in the past. During one of these instances, he had willingly gone to the VA. A second one, it sounds like, involved an argument with his wife. Because of the VA being involved, Beacon was contacted, and they didn't see any reason that this individual's firearm should be removed. They didn't have any concerns for violence. He was medication compliant. And Dr. Rosenbaum was also consulted and agreed with Beacon. It sounds like the DA was consulted and said, well, it just sounds like they were less than helpful. Thus, the final report was filed with BCSO saying that there wasn't any reason that was discovered that this person should have his firearms taken away.
I also forgot to mention he is pretty overweight and almost entirely wheelchair bound, making it even less of a reason for me to feel like he's an immediate danger to anybody.
Yeah, that
Thank you, Dr. Foray. Thank you, Mark. I particularly like the recap on how helpful the DA was not.
It was pretty awesome. I took the paperwork to BCSO as well on the 5th floor, and they basically looked at me like, what is this? What do you want me to do with it? And I was like, well, I don't know. And the thing, it says you guys file it somewhere. So I guess do that.
Hopefully experiences like what you had help other officers in the future file this type of stuff. Before we get into recommendations for Detective LeClaire, does anybody have any follow-up questions for him? Something that he can clarify for you all?
I have a question. I mean, I think from your presentation, I gained an understanding of what the red flag law basically is, but could you or others kind of, what is that exactly, or what should I know about that?
Basically, a family member will fill out an affidavit stating, like, you know, there's a bunch of questions on there that they have to answer. How many firearms do they own? What are the reasons, you know, that you're concerned? Just kind of a whole background, like what are they diagnosed with? Are they, you know, things like that. And then what I do is I do my background. And then, where is it? Basically, there's a list of things that I basically kind of have to hit to go, yeah, I should file this or not. Which here it is, the basis for petition. And it says the law enforcement officer has probable cause to believe the following factors should be considered by the court. And it goes with a recent act or threat of violence by the respondent against self or others, pattern of acts or threats of violence within the past 12 months, mental health history, abuse of controlled substances or alcohol, previous violations of any court order, previous red flags filed against them, criminal history, convictions for violent felony offenses, violent misdemeanors, domestic violence or stalking, and the history of the use, attempted use, or threatened use of physical violence against another, any recent acquisition or attempts at acquisition of a firearm by the respondent. So those are kind of like all the criteria that you go off of to say, yeah, I think this should happen and go to the court or not.
And so basically, Dr. Frey, it is a emergency restraining order against someone's firearm, where somebody is so concerned and there's such proof that this person might be a danger that law enforcement has to go in and take their firearm and keep it for safekeeping.
Okay, awesome. Thank you, guys.
Any other clarifying questions for Detective Leclerc? I had
Hi,
one.
Tasia here.
Oh, go ahead, Tasia.
Sorry. So, this is all fairly new, and I'm feeling like a little bit of a cart before the horse scenario, just based off of his story. But I've yet to hear about at least a success story and how this is actually playing out in practice. I'm just wondering, is this something that nobody's like really accomplishing yet, just because of all these barriers and lack of cooperation from the DA, or just really not having the infrastructure in place to implement this law? Or are you guys hearing of other detectives within the department that are successfully pulling this off in accordance with the SOP? Sorry, it's kind of a broad question.
I haven't heard anything about anybody completing one.
Yeah, as far as APD goes, I haven't heard much about success. I think we're the only unit to give it a try. Although we are lucky to have several other agencies here on the network. And I believe like King County and Sergeant Lockhart has had the red flag longer than us, the red flag law. I don't know if you guys have had success, or if any of the folks from Illinois have had success with this, or even haven't.
You want me to go into it now, or you want me to wait till later?
Sure, let's go into it now.
So for ours, we've had it, I think, since 2016-ish. And so I was going to actually ask Mark just one more clarifying question. Is the wording of it, does it say something to the effect of like poses a significant danger, or what's the standard that they put in there? And if you don't know it, just whenever you get it.
I can add, it's actually elevated risk for committing interpersonal violence or attempting suicide.
Say that one more time, Doctor.
Yeah. It's elevated risk for committing interpersonal violence or attempting suicide.
Okay, so in that, the tough parts were figuring out what that is, right? So a couple of the learning pieces for us, ours is poses significant danger.
Ours is
so. Okay, so it's being able to have that standard out there so that whatever group, and I assume it'll go through your crisis unit, it'll be stuck with this going forward. But where we were having issues just like you is nobody knew what to do. And we actually partnered with Seattle Police Department. They were actually excellent at going through this. They were able to get partnership, which, you know, it's whoever draws the short straw or who's ever very determined, maybe, probably should take this on, because obviously this is not going away. You'll be using this more and more, whether you want to or not. And what we did is they had an officer, we had one of our detectives partnered up actually with the prosecutor's office and literally from scratch walked through the different elements where Mark was saying they didn't even know what the heck he's talking about, right? Because just like here, they put it into law, but that doesn't mean anybody knows that it was in law or what they had their skin in the game. So literally they walked through the process, literally going to talk to the judges, going to talk to the court clerks. How are you going to issue this? Do I have to wait in line at 9 o'clock in the morning, right, behind everybody else? Or, right, just all the nuances that come with it, that if you do the work ahead of time, it will save you what Mark's gone through, because at least you're doing it on your terms, not having somebody have that desire or, you know, that push. So just going through, literally walking one that maybe nobody's even got yet, right? A make-believe person, and literally walk it through, find out where your barriers are, who influences them. If you've got to get a prosecutor on your side or whomever, maybe one of the right, somebody from behavioral health, go through that process. How does it look like when we go to serve it in the field? Will SWAT come out to serve one when they are barricaded in their house? Ours is no, right? But again, you got to play those scenarios out. And then again, some of the big pieces for us were, one, getting past the process, documenting it. And then another thing to consider, like Mark was going through, SPD, as you guys are familiar, is under DOJ consent decree. Okay, so they have to document everything, and in some parts, right, it's a nightmare. In other parts, it's very good. But one of the things that they got jammed up on, so maybe to avoid that for you, is have a panel, right, of diverse folks, and maybe somebody outside of I don't know if Dr. Rosenbaum counts because he's employed by law enforcement, but somebody outside of it on the panel to review these cases, so that it's not Mark saying, I don't think we need to serve this order, right? They don't meet criteria. Have a panel that reviews every one of these, so that when you get sued on the backside, because it's coming, you are showing this is how we did it, right? Mark did all this good work. He called all these places. It's all documented. And then I presented it to the panel. They reviewed. Maybe they had an idea to call somebody else, or however that may be. We did not meet. We figured they did not meet the elevated risk as named in the law, or however it's worded. And right, so we decided not to pursue it. But they've done, I don't know, 200 and 300 of these. I mean, it's way up there. But they got jammed up for, okay, what's the problem? Why did you serve this one and you did not serve this one? And being able to, right, and they were making good decisions. It's just they didn't document it. They didn't have a set panel to review it. So it looked shady when they asked the tough question. And well, Mark said it didn't meet criteria. Well, who the hell is Mark, right? How much does he know, right? And he's saying, hey, it was my first time, right? Or whatever. And that doesn't fly, unfortunately, right? So just some of the stuff. And I've got, whoever gets stuck with this, if you want me to send it to you, Ben, I've got a really good, it's a little bit older, but a really good PowerPoint that SPD put together, talking about all the different ones that they served, what were some of the scenarios that they ran into, some of the barriers, et cetera, because you're going to run into a lot. But the toughest part is literally that process. And for us, one last piece, sorry to bogart this whole thing, but one last piece that they ran into is, like, for ours, just the interesting part is, so it can be petitioned by the family, right, close family member, et cetera, or the law enforcement agency. So you can do it up here, and so I don't know if it's the same there. The law enforcement agency can petition for the IRPO. If you are, the law enforcement agency can do it, then let's say Mark's the detective working this. If he writes it, he can't go serve it. And so just little nuances like that, of find that out on the front end. You don't need it blowing up on the back end when something goes sideways, and then here's the detective that wrote it. went out to serve it, trying to do the right thing. They've got all the history, right? Maybe they've dealt with them. They can help de-escalate whatever it may be. And it's written in there that that can't happen. So I'll make whatever I've got available for you guys if you want it.
Thanks so much, Sarge. I'm really glad you tuned in. That's all very helpful information. And I want to thank Detective LeClaire for spearheading APD's efforts to answer all of these questions and possibly soak up these initial lawsuits. That's very generous of you, Detective LeClaire. A few comments from the chat. Detective Bellio from Colorado says, the judge on my case said he specifically prefers when law enforcement completes the application versus the family. I can switch to a computer with audio visual if this explanation would be helpful. Completely up to you, but that is a very helpful statement. I think ties in with what Sergeant Lockhart was saying about the nuances of this stuff.
Just really, Ben,
go ahead.
in ours, law enforcement isn't allowed to be the reporting party.
I see.
It has to be like spouse, grandparent, child, that kind of stuff. It cannot be a law enforcement officer that's doing the initial, affidavit saying this is why I think guns need to be taken away. We just do the investigation after someone else fills out the affidavit.
Gotcha. As far as if other agencies have had success, again, comments from the chat saying it looks like our partners in Illinois have served this successfully a couple times. And obviously King County along with Seattle PD have had probably the most experience in the country. I believe was one of the first places where we saw the red flag law. And so Sergeant Lockhart's generous offer of sending us materials would be greatly appreciated. I'll make sure those get to the appropriate people. Any other clarifying questions or recommendations for Detective LeClaire?
Hi guys, this is Detective Bellio. Can you hear me okay? All right. Sorry, I had to get out of my office where my peers were, so I didn't have a way to do this with like a headset. So thanks for the standby on that. I understand that the case that you guys are working on, you said that law enforcement can't petition. Just for those agencies in areas where law enforcement can create that application is kind of the way I heard it read, or I think the terminology is kind of interesting, but affidavit or application, whichever you choose to call it, that initial paperwork. The reason that I was told by the judge that they prefer when law enforcement executes that part of the application is because then law enforcement knows the risk of going in and executing that order, since it's pretty dangerous. Particularly here in Arvada, Colorado, it would hit our SWAT matrix, I think, inevitably. So we would execute it with SWAT. In the circumstance for my case, but I'm the only one who has done one at the department. So luckily I set the standard, but didn't have any previous expectations. So I was fortunate to kind of figure that out on my own, but I had a lot of help from our city attorney. And that was hugely helpful. So when we were going up to the county court, because we're a municipality, when we were going up to the county court, he was able to liaison and kind of speak with them about those processes. And you guys talked a minute ago about doing like a mock creation of this application so that you know the processes that need to happen. I think that's a great idea, because being up there and not really knowing what to do and where to head was a little overwhelming, having done the first one. But in my case, we had a individual who was living with his 94-year-old mother, and I think he was around 60. They were both in need of significant care. She was pretty cognitively stable. He had dementia, and it was getting progressively worse. He had access to, I think we removed between 8 and 12 firearms. Some of them were larger, like long guns, some of them were smaller, and some of them were replica or fake guns. But beside the point, he had menaced a neighbor based on this false presumption that the neighbor was out to get him, kind of this nonsensical delusion that he had. So we were able to use that crime as the stem of our case, which was helpful then when we went to court, because that particular, so I'm our elder abuse detective. This doesn't normally fall in my realm, but given that the mother was 94 years old and there was a safety concern, we were able to execute that successfully based on, that was kind of the circumstances. So I don't know if this came up earlier, Mark, when you were explaining everything, but the only thing I would say about background is just, sometimes talking to neighbors is helpful. Has this person made any off the wall claims that maybe might have been missed in a police report that could be helpful or whatnot? I know a lot of times it's really hard to get medical information just due to HIPAA. So sometimes we maybe don't know the ongoing mental illness or the ongoing mental health history, but friends, family, neighbors, that kind of information's huge. So again, sorry for the technical difficulties. Hopefully that was helpful. And if anyone wants to review anything that I have, I'm happy to send it out.
Awesome. Thanks so much. Yeah, and we would be happy to take a look at whatever you and your agency have put together. It's just going to be extraordinarily helpful for us here at APD. Any other recommendations for Detective LeClaire? Clarifying questions?
Hey everybody, this is Nancy Martin with Presbyterian. So we're going to get into a lot of the nuances of our state-specific law, but regarding this case, Detective LeClaire, my biggest question is, it sounded to me that you did a lot of work investigating the daughter's claims, and that it sounds like you have some instruction regarding, areas that you have to remark upon in your petitioning statement. But I also wonder, within New Mexico specific, if it's a misinterpretation of the law to really think that the law officer has to either really support or not support that, that desire for petition from the reporting party. I'm basically bringing that up because I almost wonder if it's the burden of the court and not law enforcement. It sounds like you put a lot of time into kind of investigating what the petitioner or the reporting party was saying to you. And I really wonder if that's the court's burden. As I had read the law, it seemed to me that it was the court's burden. And certainly, I would imagine in cases where a reporting party and the petitioning officer have different opinions, that they're going to spend a lot more time and effort making a decision on those cases. So I think for me, hearing kind of your thought process about not agreeing with the petition, I'm wondering, do we always need prior violence or use of a firearm to temporarily remove a firearm when there's a family member concerned? And I think that's the question that will keep coming up for me. And in my work in emergency psychiatry, I have to do this all the time, right? I have to weigh what collateral is saying to me about a patient's presentation versus what the patient is saying themselves. And in the way that I interpreted this law, I didn't think that was the burden of the law enforcement officer. So we can talk about the nuances in the lecture piece, but that would probably be my recommendation in further cases. If you have a concerned family member, that you just kind of do what you did, go through those criteria, write up the report, and then let the burden of deciding be on the court.
I guess my concern was, and I'll read it directly from here. It says, in support of this petition, the undersigned law enforcement officer swears and affirms that based upon credible information contained in the attached affidavit, there is probable cause to believe the respondent poses a significant danger of causing imminent personal injury to self or others by having custody or control of a firearm, or by purchasing, possessing, or receiving a firearm. The undersigned law enforcement officer has probable cause to believe the following factors should be considered by the court when determining whether to issue a protection order or not. So I took that as I have probable cause to believe that he's an imminent risk, and I'm swearing and affirming that by signing this and sending it forward. Because his last incident was almost a year prior to this being issued, I felt that I didn't have enough probable cause to believe that he was an imminent risk. So that's why I didn't go for it. Because otherwise it's no harm, no foul, let's just file it and see what happens in court. But this makes it sound like it's my responsibility and I have probable cause, which is basically what we need to arrest somebody, to believe that he's an imminent risk. So that's why I didn't do it. If that makes sense.
Yeah, that makes sense. Thank you for explaining that.
Yeah, of course.
All right, any other final recommendations? I want to make sure Dr. Martin has enough time to do a presentation in which we're obviously very interested in. So any final recommendations or clarifying questions for Detective Leclerc?
I was just going to say, I like the idea of having a panel. I think it's good that Detective Leclerc sort of loaded the boat with as many people as possible, so that if things go bad and the boat sinks, we're all in it together. And so I like that idea. So good job.
I agree. I think the panel, especially if it was like Sergeant Lockhart said, non-law enforcement folks, it's easier to defend that decision in the litigation setting. All right, let's go ahead and get started with our didactic, which is about red flag laws in a psychiatric setting, presented by Dr. Martin from Presbyterian Hospital here in Albuquerque, New Mexico.
Hi, everybody. I'm excited that everyone's interested in this topic. I'm very interested in this topic from the healthcare perspective, and I'm hopefully going to make a case for why that's important from the type of work that I do. I know that this can be a pretty politically charged topic, but when we're talking about the removal of firearms, I want to make sure that everyone's understanding that this is temporary and with real valid concerns for someone's behavior. For me, the passing of this law, I think, added some tools in our toolbox on keeping people safe, which is really, really hard to do when there's a firearm involved. So I'm going to show you some data today. It's pretty sad data. It's not going to be surprising to anybody on the call. But I think, I'm really, really happy this law passed. There's things that need to be changed, and we've got some great people in APD who are working with the law, the lawmakers on some of these tweaks. And so we'll just dive right into it. Can you all see my screen? Okay, good. Okay, so a lot of people don't know what this is. The red flag law is kind of easier to say than what's called the extreme risk firearm protection orders, or ERPOs. Every state likes to have a different name for every part of their laws. I was just talking about this during the 40-hour CIT lecture with Ben yesterday. So this is like the mental health code version of this law, but it was called Senate Bill 5. And it actually went into effect in July of last year. So it was meant to be, within constitutional limits, the ability to address access to firearms, legal firearms, by persons who are at an elevated risk of committing interpersonal violence or attempting suicide. So for, I think, a lot of psychiatrists, we had a lot of questions about this. And I spent time talking with both the two, the lawmakers who really tried very hard for a long time to get this passed through. And then I spent a lot of time talking with Lieutenant Dietzel through APD about this as well. So, I'm really talking to a group of people who understands the risk of firearms. And understands that really horrifically and personally. So this is not meant to be didactic anyway. I know you all understand this, but I just wanted to show you some numbers and why it's important. And that's because firearms are involved in most violent deaths in the United States. We sure love our guns, and we tend to use them when we're killing each other. Also within mental health, firearms are the most used and obviously successful method in about half of all suicides, and then 3/4 of all US suicides and homicides. And it's the method, right, that's most fatal. It can take any risky situation and turn it into a fatal situation. So nine times out of 10, a person who has a gun and attempts suicide with that gun will die by that gun. So it's a very, very lethal means. And so when somebody presents to the ER, where I work primarily, and they have access to a firearm, it does significantly change what it is that we do. Whether that's, having them stay in the ER for a longer period of time to observe them and hopefully secure their firearm within our rights as a hospital system, or even admitting them for further observation. So it definitely changes our risk stratification of that person's safety. And so, again, within constitutional limits, this court order, it basically authorizes the temporary removal of firearms for people deemed to be dangerous to themselves or others. So we're really, very lucky to have other state agencies here today who've got more experience in this. But I wanted to give some New Mexico specific data to prove the point why this is so important. So about 6 years ago, ATF, the Bureau of Alcohol, Tobacco, and Firearms, they placed New Mexico 4th in the country in terms of registered gun ownership. So we're right behind Wyoming, Arkansas, and the District of Columbia. So we have about 80,000, or at that time we had 80,000 registered firearms. And with a population of just over 2 million, that's about one gun for every 25 people. And so, by comparison, Nebraska has the closest population numbers to us. And there's one gun for every 135 people there. So we have 1 in 25, they're 1 in 135. And that's just registered firearms. And that's 6 years old in terms of data. So we sure like our guns in New Mexico too. So what I wanted to show you, unfortunately, this is the Office of Medical Investigator data. This is all public data. The OMI here in Albuquerque, they investigate about 43% of all deaths in New Mexico. So again, we're not accounting for total deaths in New Mexico. This is 43% of the total deaths that were investigated by the OMI. And they put together this data, which I wanted to show you today and why this is so important. So in 2019, they investigated about 8,000 deaths, and they totaled these by gender and by manner of death. And our suicide rate in New Mexico, in terms of things that we're good at, suicide is one of them. So we're consistently higher than the national average. We have about 3% of all deaths in New Mexico are completed by suicide, compared to 1.6, which is the average nationally. And that's based on 2018 data. So you can see here, we had 493 total, both male and female suicides. And then the bottom graph breaks down according to race and ethnicity. So significant white, non-Hispanic representation, which is pretty consistent across the country's data too. So this graph is basically showing you a decade's worth of data of completed suicides in the state of New Mexico since 2010. And unfortunately, that trend is increasing. We did decrease from 527 in 2018. I'm very interested in seeing 2020 data as it relates to the pandemic. They just haven't compiled that yet. So this is the same information, essentially just suicide deaths by age and gender. And so you can see, our highest group is age 25 to 34. For males, that's that gray bar. And then the ages 45 to 54 for females. Okay. And then this is just showing you the breakdown of race and ethnicity a little bit different as well. So it's predominantly white, non-Hispanic represented in this group. And then in 2019, they break down cause of death. So not manner is different, but cause of death is predominantly gunshot wounds for the completed suicides in New Mexico in adults, with hanging right behind it. So unfortunately, I have to show you that same data in the adolescent population. So again, this is a decade's worth of information, but we're seeing that same trend of upwards completion. With what you can see here is significant in the ages of 15 to 19, with the the gray bar being males and the striped bar being females. And then same data according to race. So again, predominantly white, non-Hispanic, and white Hispanic closely behind that. And then cause of death was 16 were completed by gunshot wounds, and then 16 by hanging as well. So, I know that's really upsetting data to look at, but I hope that shows people that it's not only suicide is a really big problem for New Mexico, but having access to a firearm seems to be a really big problem too. So this map is showing you as of October of 2020, there were 19 states that had enacted some version of an extreme firearm risk law. And being that every state is different, each of these is worded differently, but essentially they all have the same goal, which is to temporarily allow law enforcement to remove firearms for an at-risk individual. So I see there's a lot of questions around the process. And for me, there were even more questions around why they wrote the law the way they did. So I asked some really difficult questions of the sponsoring lawmakers. And they, one of the things they said is we really wanted it passed. And two, when you write a law, they said that they're not always sure how it's going to, to work kind of in vivo. So there are things they want to amend. But essentially the process in New Mexico is that there's a reporting party that must fill out a statement. And we'll talk about who constitutes a reporting party. And you guys can tell me who's missing from that list. And then a petitioning officer must also fill out a statement. Both of those statements need to be notarized. And then the petitioning officer, I was told, has to go to district court and have a judge take a look at it to either approve a temporary order or not, and that the respondent then must be served. So when I'm thinking about the utility of this law in the emergency room, the minute that I heard that the turnaround time on this is 10 days, it's not useful for me to try and pursue one of these in the ER. But then I found out I am not included in the reporting party too. So we'll talk about who that encompasses in a second. But when this law was being presented, there were a number of people who had strong opposition to it. And that included a lot of tribal law enforcement agencies. So the way that they address that in the actual writing of the law is that if the law enforcement agency disagrees with the petition, that they still are required to fill out a statement saying why they're declining to support that. So I really appreciate Detective LeClaire talking through that process, because I that's the other half of it I don't know. So for us in healthcare, we're not included in the reporting party, and then two, the timing of it is not useful in the emergency setting. So let's talk a little bit about that difference between the petitioner and reporting party. So in the law, the petitioner is only a law enforcement officer. Okay, so nobody else really can do that. And the reporting party was really strangely inclusive of some pretty contentious relationships, in my opinion. So it included spouse or former spouse, parent or present and former step-parent, present or former parent-in-law, grandparent or grandparent-in-law, co-parent of a child, and I would assume that's an adult child, person with whom a respondent has or had a continuing relationship with, and then employer or public or private school administrator. So can anybody pipe in, kind of mention who's missing from this group?
Psychiatrist?
Yeah. So hospitals and healthcare professionals, right? They weren't listed. And then they make kind of note of this vague person with whom there's a relationship with, but it had to be personal in nature, and they really didn't define what that meant. So I asked the lawmakers, why did you leave mental health professionals out of this? And they told me they didn't consider it, which, I don't know if I believe that or not, but that's what they said. And this is one of the areas they're going to try to amend, because I think we can all imagine friends or even personally any of these relationships being contentious or having ulterior motives of having a firearm removed. And for a lot of pro-rights pro-gun ownership, this is where people took issue. They didn't want, in a contentious divorce, a person to be able to vindictively remove a firearm when it wasn't indicated. So I think, unfortunately, within the law, we kind of created some reasons for people to be hesitant of using it. So hopefully that gets cleaned up a little bit, and can move towards a more standardized version of eligible petitioners. And in the reading that I've done on this, it seems like those people should be law enforcement officers, family members or household members, and intimate partners, and then licensed healthcare professionals. Kind of not this like former or present stuff that we're seeing in New Mexico code. So back to the process, it's a 2-hearing process. The first hearing is ex parte, meaning that the person in question does not have to be there. The allegedly dangerous person does not have to be present. And the judge can issue an emergency order to disarm the accused for up to 10 days in New Mexico. And unfortunately, this did not get tied to a mental health evaluation. And so this is where, in my opinion, we got this law wrong. I know we have representation from Colorado today, and we'll talk a little bit about how that's different there. I don't know that law as well. I haven't read that law, but the Colorado properly connected their red flag law to the existing mental health commitment systems. So from my understanding and my reading, when Colorado court grants the year-long petition, they actually have to have a hearing to determine whether the person requires court-ordered mental health or addiction treatment. And I think, some people could see that as punitive, but in fact, we're trying to address the dangerous situation to begin with, right? They're trying to direct and then connect people with treatment for any underlying causes that even alerted us to this issue to begin with. And New Mexico doesn't mandate that at all. So the law makes some vague reference to the court making recommendations for mental health or substance abuse evaluations, but it doesn't appear to be requiring those. So I think that we kind of failed in that area, that there's not even a mandated evaluation. Within these extreme risk firearm orders, we have a lot of concerns about HIPAA, and I think Detective LeClaire talked about this in the case, right? That he didn't necessarily have the consulting ability from anybody, but then also there was this like semi-burden of investigating these kind of like these areas of what the family was saying, and I'm sure you'll run into roadblocks with people disagreeing with the release of that information and how that could affect a patient in their care. First off, there are liability protections in place for licensed healthcare providers, as long as they're acting in good faith. And so that's kind of written into the law, as long as they're acting in good faith and providing information to the law enforcement officer that they can talk about this with any agencies connecting them. And that disclosures, are if they're to prevent imminent threat to self or others, that it's considered reasonable. But I imagine that this would be an area where law enforcement agencies would run into some trouble. And then kind of around privacy laws, like who can find out about this, right? Like, can your employer find out about this if you had an ERPO served on you? From what I understand, this is not public data, like both the number of cases that have gone through or been petitioned, but it should be, like, the number of it should be maybe devoid of personal information, but the number of it should be. So I think that the state's still trying to figure out how to collect that. But more importantly, this is not criminal either. So we don't want to be stigmatizing people who have a removal of a firearm, but we're also not tying it to mandated evaluation or treatment. So it's kind of like, well, what's going to happen in that year, or what's the best case scenario in that year of what this law is going to do. So those are my thoughts on ERPO and HIPAA. And then finally, like, does it work? Do these laws work? For all of the time and effort that Detective LeClaire put into this case, would this have been successful? And so Indiana and Connecticut have had extreme risk laws in place for some time, and I'm sure the other agencies have had them longer as well, but these are just the two studies these are the two states have studied this. And two of them, studies from both of those states, showed that for every 10 to 20 firearms that were successfully removed sorry, not total firearms, but total removal of orders that were completed, they estimated that 1 suicide was averted. So we always talk about number needed to treat in medicine, about how many people do we have to give the COVID vaccine to, for example, to save 1 person from dying from COVID. And so if you talk about 10 to 20 to save 1 life, that seems worth it to me. From what I had understood when I talked to the lawmaker about this law a couple months ago, that there were 4 successful removals in the state since the law went into place. And one of the lawmakers is convinced that it saved 2 women's lives. So I know that most agencies don't really know what to do with this or how to use this. I guarantee you that most people don't know about this either. But to have already saved 2 women, I think is pretty amazing. So that's the content I have for you today. I have prepared kind of like a cheat sheet for medical providers about if you have a person in the ER or in a clinic whose family member or any one of those other reporting persons wanted to pursue this, I have kind of a cheat sheet of how you would do it from the medical side, and I'm happy to distribute that. And then it sounds like there's been some great ideas about kind of having a separate area for law enforcement to work on with these cases, but I'll take any questions. I'm